My name is David Wilkins. I'm the director of the Center on the Legal Profession here at Harvard Law School. And on behalf of the center and also the law firm of WilmerHale, we are just delighted to welcome all of you here for what we hope will be a stimulating and timely conversation about really some of the deepest issues that I think we're all facing in the profession here today. We have a terrific, as I said, lineup of speakers, but an even more terrific group of people here in the audience, and we really want to make this as much as possible a conversation, one that we will begin today but can't possibly end today given the broad number of things that we want to talk about. And so we hope very much that this will be the beginning of a very long and we think badly needed discussion about the topic of lawyers as professionals and as citizens in all the various ways in which lawyers serve. We are, as you will see, recording this in the back of the room. This is for purposes of putting up on our website so that we can have a much larger group of people, even than the large number of people who are here in the room, to engage in this conversation. We urge you to go to our website, not just to look at this, but to look at a range of other things that we've been doing over the course of now the past several years. We have a weekly speaker series with leading professionals, which are on our website. We have a number of other conferences there, and we urge you to stay engaged with us through our website. We're also being tweeted, I've been told, by people much younger than I am or hipper than I am in any event. So if any of you want to contribute to that, I don't know how to do it, but other people can help you. We also have a special issue of our new digital magazine, The Practice, which is devoted to this set of issues, which there are little cards on the table there that show you how you can get access to that. And we would very much love to have all of you as subscribers to this, because this is one of the ways in which we're trying to take the conversation and make it more broadly available. I'm just going to say a few quick words about logistics. You've got the program here, which sketches out our day. As you can see, it's a very full day, but hopefully a very rich day. We are going to, I'm going to first introduce the dean in just a second, who will welcome us to the law school and give some remarks from her incredible perspective, both as the dean of the law school here, but also as an important member of the board of the Legal Services Corporation and one of the world's leading scholars on many of the issues we're talking about. We'll then hear from the other authors of our essay, our trim little essay, which we were delighted that so many of you actually have read. We are also having many people here who have commented on the essay, and those comments are being put on our website as well, so you can get access to them. You'll be hearing from some of them as speakers, many others as members of the discussion, and we hope to take all of these things and eventually make them widely available, either in an edited volume or a monograph. We haven't quite decided yet. We're then going to go straight into the next panel, which is Robert Gordon from Yale Law School and Kim Coopersmith from Aiken Gump. And after that, we'll have time for discussion and question and answer. I just have to say we're going to have a hard stop here at 11:30 because we have another major event that's coming in this space, and we've promised the dean, who's now looking at me, yes, we will have a hard stop at 11:30, that we will exit this space in time for them to turn the room over for a noon event. This wall is going to magically raise, and we're actually going to walk out that way back to where we were at breakfast, and that's where the working lunches will take place. All right, I think that's enough boring logistics. Let me please introduce Dean Martha Minow.
On a slow news day, if there are any journalists left in the world, they write about the crisis in the legal profession. And if it's really slow, they write about the crisis in law schools. There have been more stories and hand-wringing and discussions about this in the last 5 or 6 years than I think in the history of humanity. What has been missing in this discussion is a serious acknowledgement of the ongoing and indispensable role of lawyers as citizens, and actually the word duty, which appears in this important paper. Woodrow Wilson, remember him? He once said, at every crisis in one's life, it is absolute salvation to have some sympathetic friend to whom you can think aloud without restraint or misgiving. And what I know will happen here today is an actual conversation, thinking aloud, and I hope without restraint or misgiving. And why do I have confidence that that will happen? Because my friend Ben Heineman said to me a couple of years ago when he joined this university as Distinguished Senior Fellow, he said, what can I do to be helpful? And I said, Ben, would you write a short, notice the word, a short statement about where we are, what the profession needs? You've done such important leadership in GE and other places. And, you know, bless his heart, Ben said, okay. But then he said, actually, I can even do a better thing if I draw in Bill Lee and David Wilkins. And actually, I think that is absolutely the case. So Bill Lee, who's splendid in superb leadership of his outstanding firm, his own work as a hardworking litigator who seems to be on every continent at every moment, and he's also, let's acknowledge, my boss because he is the chair of the Harvard University governing board, but I am his boss because he teaches here. We are just, ecstatic and incredulous that Bill found time to do this. And, you know, the indomitable David Wilkins, whose Center of the Legal Profession has orchestrated not just this event, but quite frankly, the most serious, most sustained research about the changing shape of the profession globally that's done anywhere. This paper has drawn in an extraordinary dream team, you guys, the commentators, from every sector. And we have great confidence that actually we don't have the answers here. What we have is a lot of questions. And I hope a more constructive frame for the conversation than we've had before. So I just briefly am going to offer my contributions because David told me I had to. David's also my boss. You know, I'm in this unusual position. You know, if I weren't a dean, I would want to be Oprah Winfrey. I've always wanted to like have the microphone, go ask people questions. And I have that experience. I'm invited into people's offices. They would never, ever entertain me as a professor. But somehow, dean of the Harvard Law School, so I'm there, you know, I'm with the, you know, presidents of countries. I actually talk with, of course, the heads of banks, law firms, startups. It's an unbelievable thing. So I'm pretending to be Oprah Winfrey, and I ask people, what's going on? What do you predict? What do you think about the claim that there's a crisis? What difference do lawyers make in the world? Et cetera, et cetera. So just based on that completely impressionistic and opportunistic perspective, let me just say this. And as David says, I am vice chair of the Legal Services Corporation, so in my other life, I spent a lot of time on low-income people's legal needs. What I see is 4 major questions. I mean, the paper has 3 problems, 4 duties, so I'm offering my 4. We just had Passover, so what can I do? So, you know, the downturn in 2008 simply exacerbated and accelerated larger trends and issues, as many of you in this room know and have said so publicly. First is the cost of legal services. The cost of legal services, making it beyond the reach, certainly of most individuals, challenging for businesses of all sizes, and that includes even large corporate clients that have worked very hard to try to control legal costs. This helps to explain the rise of the in-house counsel as the most powerful legal player. But it's especially harsh for the poor. It's especially harsh for people who have no other options. And, you know, law is not self-executing. And I can't help but note 1 in 5 Americans now have incomes below the threshold for eligibility for legal services in America. That's meaning $14,000 a year for an individual and $29,000 for a family. So that's where we are right now, and we don't have anything like the availability of resources to meet their needs. In fact, we have a shrinking pool of resources. Cost of legal services, but it's a problem across the board. It's a problem for the wealthiest corporations as well as for poor people. Second, globalization. The needs for expertise. Bill Lee ran a just fascinating program here a few years ago, presenting a hypothetical case, an intellectual property case, to 4 judges from different countries who applied their own laws with 4 different answers. And that was the beginning of the conversation. How do you practice law when you simultaneously are practicing in multiple jurisdictions? How do you give advice? How do you actually have the expertise and responsibility to do that? As well as globalization presenting the competition for who will provide legal services, and maybe even not legal services. Maybe in another country it'll be accounting services, or somebody else will claim to be doing it, as well as labor costs that may be cheaper in other places, and many in the room are more expert than I am in the possibilities of even global firms doing arbitrage on labor costs. Third is new technologies. Obviously great opportunities, but also great challenges. So I just can't resist telling you a few of the challenges. I get an angry phone call. I get angry phone calls basically every day, but I got this unusual angry phone call attacking the Harvard Law School for creating a phone app in immigration and naturalization services. So I call over to our clinic. Don't tell them I'm going to say this. I said, what did you do? Did you create this app? They said basically, what's an app? So I knew then it wasn't they who had done so, and I tracked it down. It was from the Innovation Lab at Harvard. I'm on the board of the Innovation Lab. I said, how did this happen? It turns out it's business school students. I say, this is unauthorized practice of law. They said, look, you're not doing it. We're going to do it. We're going to come up with a digital navigation tool to help people find their way through a complex bureaucracy, and it's completely happening. See one of my alums who runs a very large global law firm. I said, how's business? He says, which business? We're in 5 businesses. And indeed, they have created online data analytics businesses, state research businesses, a one-stop compliance tool, et cetera, et cetera, et cetera. The use of the digital is tremendous in its opportunities, but also its disruption. The Center for the Legal Profession has held now some wild sessions on what the disruption means in opportunities, but also disruption for the way that we have practiced law in this country for a long time. Just can't resist one more story. A student quits his summer job, which is not a great thing to do in this market, saying, they asked me to read these contracts and compare terms, and I majored in computer science at Stanford, so I wrote a program to do it, and they weren't happy. Okay, we're going to go on. The fourth problem is the distrust of established institutions. I can't believe I'm saying this as a 60s person, but actually it's a big problem that people don't trust the police, they don't trust the courts, they don't trust the law firms, they don't trust the regulators. This is a big problem in this country. It's a big problem around the world. A lot of my own work is in post-conflict societies where the lack of distrust for state authorities is the predicate for the next civil war. This is really serious. If you do not have an operating and functioning legal system that is respected by people who otherwise disagree, you do not have the possibility of anything else. So I don't want to get too grand about this, but whether it's corruption, and I am from Chicago, so I know something about it, or it's violence, or it's simply the growing inequalities in this country and elsewhere. The distrust is corrosive, and if we don't address it, it is really going to affect everyone's life. But there are also new opportunities in each of these areas, and I have 1 minute in which to tell you what I think they are. I'll be so brief. I do think that the digital in particular allows a possibility for blended services, as it does for blended teaching. So Stateside Legal Services is an interactive website associated with the Legal Services Corporation that helps service members, returning members of the armed forces and their families with easy access to information about the legal issues that affect them and make it tailored to their own situations, their own states, their own circumstances. I do think the global is also an opportunity, but a challenge, and I'll be very interested to hear how people here are navigating exactly what that means. I think that there is, in addition at this moment, new knowledge about how adults learn, and we need that because we're going to all have to learn things fresh all the time, more rapidly than ever before. And that certainly has a direct effect on law schools and even universities. It turns out adults learn better through experience than they do by reading. Adults learn better by having an ability to connect new information with what they've known before. And adults and everybody learn best through stories. Okay, so more on that another time. And there are great ways we can learn what business schools, engineering schools, medical schools are doing to reinvent how they teach. And indeed what many workplaces are doing in terms of adult education and continuing education. On the rebuilding trust front, I do have thoughts. Perhaps the most important one is to say we need to take responsibility, and the word duty that's in this paper is absolutely central. Because unless we have serious conversations about the duties of people who have positions of trust, we cannot build trust. My dad, who is still of counsel with his firm, Sidley Austin, was asked to speak to summer associates, and he talked about the importance of trust. And one associate came up to him and said, "How do you give the appearance of trust?" And my dad couldn't resist and said, "Well, it helps to start by being trustworthy." So as I close, let me just say, I return to those words from Woodrow Wilson. I think that this session is one of many that we are hosting, and I believe others are too, where there can be serious conversation. I want to emphasize without restraint, without defensiveness, without the claim we have to be the way that we have been, and best of all, collaboratively across the sectors. Because unless the law schools are in concert in conversation with people in law firms, with general counsel, with legal services, with the judges, we will not tackle such basic problems as a bar exam system that has no relationship to any actual competencies that anyone cares about. And I could go down the list. So I really look forward to the events here. I apologize that I will be in and out, but I commend you all. Thank you so much for being here.
Thank you all for joining the conversation this morning. To me, the foundational issue before us is whether those with law degrees can, as lawyer citizens, live the ideal of the lawyer statesperson. In simplest terms, this person, in very concrete institutional and societal settings, answers with great skill and honesty the first question, is it legal? But the lawyer statesperson is always focused on answering the ultimate question with great judgment and wisdom, is it right? Let me discuss a few framing points for the discussion, which are drawn from the shared vision that Bill, David, and I have. First, being a lawyer statesperson means being able to assume the three fundamental roles of technical expert, wise counselor, and accountable leader in the context of leading corporations, law firms, and law schools. But these three roles are important in many other settings. Second, whatever the institutional context, the is it right question stems from four ethical responsibilities: to clients and stakeholders, to one's own institution and its people, to the rule of law, and to society and the enhancement of public goods. Some of these responsibilities will be expressed as public law, some as ethics of private ordering. The derivation of these responsibilities is contextual and multifactorial. It involves prudential considerations relating to the impact of actions on diverse individuals and institutions. But it also involves normative considerations relating to ideas and concepts articulated in law and in moral and political philosophy: loyalty, care, fairness, transparency, dignity, privacy, equity, and justice. Third, the lawyer statesperson role requires complementary competencies far, far beyond core legal competencies, asking what ought to be questions, generating balanced options, developing deep empirical knowledge to the extent possible, focusing not just on setting norms, but on implementing them in complex settings, leading institutions, and understanding the role of politics, however messy, in a democratic society. Fourth, these complementary competencies are vital because law and ethics take root in extremely complex and contingent reality, which require many different disciplines to describe properly. We simply cannot solve problems or implement solutions without the best possible understanding of reality under the circumstances, even though we must often make vital decisions in a state of ignorance or uncertainty. Thus, those who aspire to be lawyer statespeople need a breadth of vision, a range of skills, and a deep moral wisdom, which include core legal competencies but go far beyond them. It is why we in the essay talk about lawyers as professionals, but also as citizens, who have a capacious, descriptive, and normative range beyond our current view of the discipline of law. I certainly deeply believe in this broad lawyer-statesperson conception of lawyer. It is vital in discharging the duties of the general counsel of a large international corporation, one of the most complex legal positions. But this kind of breadth of vision, range of skills, and moral wisdom are necessary in so many positions where lawyers are not just technical experts, but wise counselors and accountable leaders in the public sector, the for-profit sector, and the not-for-profit sector. They are necessary whether we are acting in legal roles as general counsel of the Department of Defense or the University of California system or the Ford Foundation, or as heads of great law firms or deans of great law schools, or as counselors and leaders in non-legal roles, congressional committees, executive departments, foundations, universities, departments, NGOs, and even intellectual movements. This is the ultimate challenge of the paper in the three institutions and beyond. For all who come after us, and at my age I'm allowed to use that phrase, can the next generations have a capacious vision of what it means to have the fullest life in the law, to discharge the essential roles and responsibilities as professionals and as citizens in complex institutional and societal settings, and ultimately as lawyer-statespersons. We live, as we all know, in an era when economics are transforming the law. But we should not let the economic transformation obscure in our era the time-honored ideal of the lawyer-statesperson. Thank you very much.
For those of you who I haven't met, my name's Bill Lee. I saw Judge Gertner walk in, and I thought I'd stumbled into a seminar on the death penalty, and I thought I had my wrong set of notes, but having had Ben go first, I know I'm in the right place. I'm going to try to build on what Ben has said and briefly talk about why we've tried to communicate the issues the way we have, and what are the next steps. And one of the major next steps is gathering all of you here to begin a longer discussion. We've communicated this way for this reason. We think that this is a broad issue with broad ramifications that crosses a variety of different institutions with a variety of different implications. We've written about the three because we know them the best, but as you can see from the paper, there are cross currents and there are issues at the law schools that affect the law firms, that affect the clients. But these are not the only institutions that need to bring their collective wisdom and judgment to bear on the issue. Judge Saris, Chief Judge Saris, has written a commentary on the paper, which is now posted to the website, which we would commend to you. But she talks about the same issues and their effect on the judiciary, on the people who are willing to become judges, on the people who are interested in becoming judges, and on the price that people pay to be judges. This is precisely the type of broader conversation that we want to encourage, and that's a principal goal of the paper. It is not a goal of the paper to just proselytize and say we need better leadership, we need better cultures, we need people with a better balance of professional and economic values. We hope that what will come from discussions like this are real-world events, real-world things that people can do at law schools and clients and in law firms to begin to address the problems we've identified. And that's what I'm going to very briefly address with you now in these few minutes. I think you'll get from the paper that we think it's critical that the institutions involved, all of the institutions involved, be willing to innovate and experiment and try new things. At the simplest level, I have stolen years ago Ben's 3 roles of the lawyers, and I use it in the course that Todd Rakoff, David, and I teach to first years. And to make it more memorable, I take the first role of analytical thinker and I show them a picture of Albert Einstein. And then I say that 95% of what will be taught in law school is about analytical thinking. And for our course, we're going to spend no time on it. We're going to spend time on the other two roles of the lawyers. I say the next role, as Ben said, is that of wise counselor. And I show them a picture of Yoda. And I promise you they remember. And we talk about just what that role is and what that entails. And the third role we identify for them is that of leader. And I show them actually a picture of Tom Brady, which is equally memorable. But it makes the point that leadership and teamwork is not discipline dependent. And it helps to communicate to them a broader set of roles in their first year at law school. That's the type of real-world event that we hope will begin to move the discourse forward. We also hope that there will be more experiments like the Intel relationship with our firm that's described in the paper. It is a relationship between a large firm and a major corporation, but it is a relationship that is not driven by short-term economics. It's not driven by the goal of minimizing fees during any particular quarter. Instead, for those of you who have read it, and maybe unlike David, I don't confuse clicking on the paper and opening it with reading the whole thing, right? It's a very innovative relationship, principally driven by them. But they identify three sets of lawyers that they would like to work with. Their first-chair leaders, their up-and-comers, and the newest folks coming right out of law school who they would like to work with. They try to identify a diverse group of people in disciplines and by gender and race. And then they commit to giving them opportunities from the outset to do first-chair work at a variety of different levels without an older person hovering around like me. They commit to having a relationship with us where we work together to do important pro bono work that neither of us could do on our own. And they commit to involving the youngest and newest lawyers and the people they see as the next generation in understanding the business plan of Intel, understanding the business goals of Intel, and having the opportunities to demonstrate that they can carry their water as first-chair lawyers. It is a really innovative relationship which has the long-term goals of both institutions in hand. It is a relationship that's dependent upon really candid and open feedback in both directions. And it's a relationship that's built on trust. And fees become the thing that's discussed sort of at the end of the day, not at the beginning of the day. There are also some of the really innovative relationships in the pro bono area, including the one that we describe in the paper from the Association of Pro Bono Counsel, which rather than have one law firm out there trying to do what every other law firm does, instead has gotten the power of a collection of firms in 8 different cities to accomplish work and to serve populations that no one law firm could do on its own. If we're going to innovate, if we're going to try these things, there are 2 basic principles we have to agree to. One is there's going to be some experimentation and failure. And that's just the way it's going to be. And we have to be willing to undertake the experimentation. We have to be willing to undergo the failure. And we have to be committed to executing in the long term on a set of long-term goals that better balance the professional and economic goals of the profession. Longer-term goals that address the lawyer statesman that Ben has described. Now, we don't think this is easy. That's why each of the sections of the paper ends with a section called obstacles. We know that some people think it's a little Pollyannish. We know that some people think it's a little old-fashioned. But we're optimistic enough to think that if we focus on the broad roles of lawyers that Ben has articulated, we focus on the opportunities to innovate and experiment, and we focus on executing on those innovations with long-term goals of the profession in mind, that will make some real progress. Thank you.